Please rise. The Court of Appeals is now in session. Please be seated.
Well, thank you. Good morning. Welcome to the Court of Appeals in special session at Southern Utah University. It has become our annual custom to hold a session of court down here. We appreciate counsel's willingness to come and participate here in arguing a case that actually arose in the local area. Moving away from our main base at the Matheson Courthouse in Salt Lake City doesn't just happen. A lot of work goes into sort of replicating our clocks and our broadcast of the proceedings, et cetera, in a different location, a beautiful location, if I might add. If you were at the Matheson Courthouse, you'd be on a pretty hard church pew-like bench. Here you each have your own lovely upholstered chair, which is just really quite nice. But I want to thank President Wyatt, who takes personal responsibility for our session down here. As some of you may know, in an earlier life, Scott Wyatt was a practicing attorney as well as a legislator, was at one point the Cache County attorney and argued cases before the Utah Court of Appeals. So he walks the walk and talks the talk, or at least did at one point in his very distinguished career. His assistant, Jennifer Oberhelman, and our clerk of court, Lisa Collins, play a big role in getting this to come together in the very organized and nice way that it does. We also want to thank Trooper Brian Barrett of the Utah Highway Patrol, who works with his colleagues and SUU's police force in seeing to our security and doing the weapons check at the front door. I want to make sure that all the students who are here understand that, as with any other court session, you are free to leave if you need to. Please don't feel like that's awkward or embarrassing. If you've got another class or a dental appointment or whatever, feel free to leave as circumstances may require. The other thing you'll want to do is silence your cell phone. This is a little different. At the Matheson Courthouse, if a cell phone goes off in the courtroom when I'm chairing the proceedings, it's a $100 fine. So far, it's ORM, $300, everybody else $200. My phone, for some reason, goes off more than everybody else's. We will not fine you here, but we would appreciate that if we didn't. We would appreciate it if we didn't have the disruption of cell phones going off. So please do that just as a matter of courtesy. Following the court session, we will then, I earlier said to my colleagues, disrobe and come down and sit in front of the bench. President Wyatt will conduct a Q&A session. Judge Mortensen corrected me and said, well, we wouldn't disrobe, we would unrobe. And I stand corrected. We will not be disrobing. We'll take our robes off to emphasize that at that point in time, court is no longer in session. We'll move into what used to be the convocation and is now called the A.P.E.X. series. Counsel, of course, are welcome to stay if they would find that of interest, but court is over at that point. They're also free to go, as is anyone else who might prefer to do that. So thank you all for being here. With those somewhat unusual preliminaries out of the way, let me go into my usual pitch, which is that by constitutional mandate, we are a court of record. Our proceedings are being live streamed and recorded. Occasionally, we'll go back and hear the oral arguments or parts of them, so it's very important when counsel come to the podium, or in the case of appellant's counsel, each time counsel comes to the podium, if they will state their name for the record, state their name and who it is that they represent, so that if some weeks from now we're listening to the arguments, we have a reminder of who is saying what when. We allow 15 minutes per side for oral argument. Counsel for appellant can reserve some time for rebuttal, and I'm guessing that 5 minutes is being reserved. I think that covers it then. Did I miss anything? Very good. Then let us call the case of State versus Robertson, whenever you're ready.
Kent Morgan, appearing for Thad Robertson. With me is my co-counsel, Jonathan Nish. He's a partner in my law firm. May it please the court, if I may proceed with my argument at this time. Your Honor, there are 3 points that I would like you to consider as appellate judges in this case. Point number 1 is, was there sufficient evidence at all? Every case has to consider whether or not there was sufficient evidence to sustain the case. And in this matter, I would like to make some arguments about the evidence here that I think is very important because this is a capital case. The second thing I would like you to consider is the number of jurors in a capital case, how many there should be determined. The third issue is the issue of whether or not, in this case, there was a knowing and voluntary waiver of the right to be present during voir dire or jury selection. There are a number of other issues that we have raised in our appellate briefs. Your Honor, with all due respect and with a sense of perspective, we have raised those because if you don't raise ineffective assistance of counsel for what is not raised in the trial court, you cannot consider them. That has been the law ever since I've been a lawyer. So I think that was the 1800s is when I started. But that is why we have raised those. We have not raised those for the purpose of slandering anyone. Everyone, especially in a capital case, in my experience, has done their very best and have been very professional and done what they can do to ensure that everybody has a fair trial and the jury selects things without prejudice that is outside of the parameters of the law. I believe defense counsel did so in this case, but we do have to raise those issues. Otherwise, those are waived, and we do have to allege ineffective assistance. Your Honor, let me begin with the most important issue, and that is whether or not there was sufficient evidence to convict the client in this case. In this matter, this is a capital case. That's what it was filed as. There is a potential death penalty, but when you go to the criminal code, you find that there are the least onerous of the cases, and that's a negligent homicide. People who engage in gross homicide and cause somebody's death is guilty of a Class A misdemeanor. If someone commits an offense recklessly and causes somebody's death, that becomes a manslaughter. The most common offense that is charged in the state of Utah is what is called second-degree murder. Second-degree murder is more than a manslaughter because you're engaging in something more than reckless behavior. You're engaging in either intentional or depraved indifference. The capital statute is a product from the 1970s. The capital homicide was legislated because what had happened is throughout the United States, people had charged people with murder, and without having any qualification, they were putting people to death that showed the prejudice throughout the United States. They did away with that, and they said, we are going to classify things according to what are known as aggravating circumstances, and we will not put people through a capital trial unless there is an intentional killing of another. Depraved indifference is not enough. And they did that, so we were only executing people throughout the United States, including Utah, where that was revived after the hiatus of stopping death penalty until state versus, I'm sorry, I'm getting old. The Gilmore case is, I was in television at the time and covered that for the press. That's when they reinstituted the death penalty. Since that time, we have tried to make capital homicides and capital homicide trials efficient, and a not so nice word is to make them cheap, to make them so that the taxpayers do not have to pay an overburdensome expense for seeking justice in that case. In this case, they have exercised the ability of the prosecutor to have all of the advantages of a capital case, but not have to put on notice of a death penalty case unless they feel like it at some point toward the trial of that case. And before the trial starts, they have to do it. Otherwise, the penalty is life in prison without the possibility of parole. Now, those statutes have been changed over time, and there will be an argument by able counsel for the state of Utah who's going to say, no, it's not a capital case unless you kill someone. Your Honor, I would ask you to look at the statutes, look at our briefs, and look at especially at State versus James to see if it is a capital case according to the Supreme Court of the United States, and this case especially. The reason that I started with that is there an intentional killing in this place, and is there sufficient evidence to show that there was an intentional killing?
It seems from
Yes,
the
Your Honor.
position of your brief, though, that if, as in this case, there were 3 people in the room, and Mr. Robinson shot the 2 others and they died, and so absent, if you're saying based on circumstantial evidence you can't have sufficient evidence of intent, and it seems to me that what you're really arguing is unless the defendant himself articulates, says this is what I was intending, that you would never have sufficient evidence. Can't you have sufficiency of the evidence simply from the circumstantial evidence?
Absolutely. I've been on both sides of the aisle, Your Honor, and circumstantial evidence of intent is something that you can show.
And in fact, my real question is, in the great majority of cases, if there aren't people in the room when someone's murdered, it is circumstantial evidence.
I would say
Almost
that-
always that leads to those conclusions, isn't it?
I'm sorry to interrupt you, sir. No, I would disagree. The vast majority of cases in Utah, I don't know about the rest of the United States, but the vast majority of cases are male and female domestic violence. People are killing each other because they're either together and are upset with each other as live-ins, or they are married and the process by which they want to get out of that marriage doesn't work. That's the vast majority of those cases. In almost all of those cases, you do not have a mystery of somebody just showing up and somebody dead in that case. In the vast majority of cases, the state has to prove that just because somebody is dead by a firearm or other means, that there was some basis for that person believing that they wanted to cause that person's death. I would disagree with the court that the mere existence of 2 bodies, or in this case it's 2 bodies, but in most cases it's 1 body in the room and somebody dying by a violent means, which I'm sure you're implying, Judge, that somehow shows that there was an intent
I
to kill.
wasn't implying that at all. I'm saying the circumstantial evidence here, which wasn't just the mere existence of 2 dead bodies. There are 2 items that I think constitute the greatest circumstantial evidence in my mind. One is the fact that this is a firearm owned by the defendant that he had owned for, I think, 28 years and was familiar with. So whether, that goes to how much knowledge he would have, what would happen if he fired
Yes.
that weapon. The second thing being is that your client gave a number of statements, and I would assume you would concede that a fact finder, the jury in this case, could take those varying accounts into consideration in deciding whether the intent existed.
Yes, I understand fully now what you're getting at, Your Honor. Let me address that directly. The difference between intentional killing and depraved indifference is fostered by the facts in this case. Intentional killing is where you intend somebody to die. Intending somebody to be frightened is not an intent to kill. The evidence that the jury had in this case is that he believed that the firearm, by pulling the trigger in the manner that he did, would not discharge a firearm.
Does that apply, does that theory apply to both victims?
I'll get to the other victim in just a
Okay.
moment, Your Honor. It would be nice if it did, but criminal trials are never easy for anyone. So that is depraved indifference, is engaging in activity that clearly caused a danger of death or serious bodily injury, and engaging in that activity, whether he intended to kill or not, he is guilty of second-degree murder by doing so.
But couldn't the jury reject that testimony of the defendant? They had a right to reject his testimony that he thought that he was just, or that he was intending to scare her. Isn't that right? And then draw inferences from the other evidence that he actually intended to kill her.
Judge, I would argue that they do not, is that when you have evidence before you and none of that evidence is contradicted, you may not reject it. Juries are required to follow the law. The reason we have appellate opinions, the reason we have jury instructions, is so the jury knows how to weigh the evidence before it. Judge Mortensen, you brought out I can't think of a nice way of saying it, the other statements that the defendant made, saying that, no, I didn't kill anybody, the girl in there is the one who did the killing. He made a lot of inconsistent statements. However, we now look at, is that circumstantial evidence that somebody has lied, or is that evidence that since he lied, we should reject everything that he said that is the only evidence that exists in this case with regard to his state of mind? Anybody who lies to a policeman is not guilty of intending the death of another.
Well, again, now this goes to the first point I brought up. He had owned this firearm for 28 years, and there was at least the assertion by the state that being a revolver with a cylinder, that one was able to see whether a cartridge was in the firing position. Now, you may dispute that or not, but their point was that in holding that pistol and pointing it at the woman's head, his observational point of view would have allowed him to see that there was a cartridge in the cylinder. The logical conclusion would then be that if you pull the trigger and you know that there's a round in the firing position, that shows intent, pointing at the head of a person to kill them. Why can't that be the factual basis?
Because as a matter of law, depraved indifference is engaging in activity that you know is very likely to cause somebody's death. That's the definition of depraved indifference. The definition of intent is some evidence that says, I wish to carry out the result. And in this case, there is no evidence to that. There is merely circumstantial evidence that one has to go to disbelieve what the evidence was in this case. And I would ask this court to take a look at whether or not this is a case where depraved indifference had been shown versus circumstantial evidence, speculation, as to whether or not there was an intent. And when you look at the real evidence in this case and what the jury had to deal with, I would ask the court to seriously look at whether there was sufficient evidence to show an intent to kill versus depraved indifference in this case. Let's go
Mr. Morgan, you're well into your rebuttal time.
my goodness.
Some of that lays at the feet of Judge Mortensen for asking a question right as the clock moved you into your rebuttal time. You're free to continue with your argument, but if you want to save 5 minutes for rebuttal, you need to take a seat now. If you want to go ahead and use some of that time, it'll come out of your rebuttal time. That's your choice.
Even though I'm a lawyer, I'm going to try and make it brief. Your Honor, I'll take 30 more seconds and outline the rest of my case. The rest of my case is whether or not a 12-man jury should have been selected. And my argument is that this is a Utah constitutional provision, and when you read not just the statute and read the whole statute on capital homicide, State versus James tells us this was a capital homicide.
This isn't the same statute as State versus James, though, is it?
It is not, Your Honor, but State versus James does create the legal principle that a capital homicide is not based upon whether or not the death penalty is imposed. It's whether the death penalty could have been charged from the beginning. And that's what happened in this case. Utah classifies it as a capital offense and says if you don't have 10 or more jurors determining life without parole, then you have to go down and step down to what's the equivalent of a second-degree murder. Your Honor, 12 jurors is important. It is so important that it's part of the Utah Constitution. I would ask you to seriously consider that. And then finally, Voir Dire. And Voir Dire is very simple. Was this an inquiry into the defendant's knowing and voluntary waiver of his right to be present during Voir Dire? Or was this merely, I trust my attorney, whatever you want to do is fine with me? If the critical stage of the proceeding was whether or not he would want to be present or wanted a jury as opposed to a bench trial, would that colloquy have been enough? I would suggest to the court it would be not. And with that, I will shut up and sit down. Thank you.
Very good. Thank you, Mr. Morgan. You'll have what looks like will be 3 minutes and 20 seconds on rebuttal, and we'll hear from the state.
Your Honors, Counsel, and may it please the Court, Christopher Ballard on behalf of the state. It's an honor to be here in this setting. Right here in Cedar City, as Judge Orm has pointed out, it was February 15th of 2013 when defendant took his .357 Ruger Blackhawk revolver from behind his, from the back of his waistband where he'd been concealing it. He pointed it point blank at Diane Bailey's head and pulled the trigger. He then shot Jeff Hardy, who was a mutual acquaintance of everyone there, twice. Defendant eventually told police that the first shooting of Diane was an accident and the shooting of Jeff Hardy was done in self-defense. But defendant's actions were completely inconsistent with those claims. They contradicted his the explanation that he eventually settled on. Defendant never called 911. Even though he knew that Diane was still alive. She was speaking. Instead, he went to his mother's house, and while he was there, he decided to write out a power of attorney because he was planning to kill himself. He returned then to the murder scene where he called his daughter, who lived in California. He told her that he had shot Diane, claimed that it was accidentally, and he said that someone else possibly could have been shot. He told his daughter he was planning to commit suicide because he couldn't go to prison. But then, for some reason, he decided not to. I don't know whether his daughter talked him out of it or what exactly happened there. His daughter eventually called police. They show up at the house. Defendant confronts the police outside, and he is, in the police officer's words, he's hesitant and he's elusive about what happened in the house, even though he knows that Diane, at least, is still alive. He first claimed that he had nothing to do with the shootings, that he simply stumbled upon two people who'd been shot in this house. Then he led police to believe that Diane was the shooter and that she was suicidal. And when police emphasized that they needed to know exactly what happened so that they could provide medical attention, defendant said, "Can you please give me a cigarette because I'm going to jail?" That evidence was more than sufficient to sustain the jury's verdicts here of aggravated murder. When this court's reviewing the sufficiency of the evidence, the court looks at all of the evidence in the light most favorable to the jury's verdict, and not just the evidence, but the reasonable inferences from that evidence. And the inquiry is there enough evidence to prove each element of the crime? And here, the evidence that I've just detailed certainly was. Sure, you had defendant's testimony, or it wasn't testimony, but his statements to police, which the jury heard, claiming accident and claiming self-defense. But there was nothing in his subsequent behavior, in his subsequent multiple inconsistent statements that corroborated that explanation that he eventually settled on. Given all of that, the jury was more than free to disregard his eventual explanation for what happened and to convict of aggravated murder here.
Now, in a conceptual sense, since the only direct evidence as to his intent is the report that he pointed the gun at her, meaning to scare her, not meaning to kill her, there isn't actual evidence that there is not direct evidence that he meant to kill her. In rejecting his version of events, as Judge Pullman was getting at, can the jury go the next step and say, not only do I not believe his story that he only meant to scare her, I think in pointing the gun at her and pulling the trigger, he did intend to kill her. It wasn't just reckless or depraved indifference. He actually meant to kill her. Because there does seem to be of an evidentiary leap to get from rejecting his claim to going to the next step and saying, oh, I actually think that was his intent.
Right, and Your Honor, I think Judge Mortenson's earlier questioning goes directly to that point about the nature of this revolver that he used. It was a revolver. It was his. He'd owned it for 28 years. The testimony from the state's experts was that it was, just by looking at the revolver, you could tell which cylinders were loaded, and that it was very easy to manipulate the barrel, or not the barrel, but the cylinders in order to position either an empty cylinder or a loaded cylinder under the hammer. And so the best evidence that we have from defendant's statements is that he was upset with Diane and Jeff, that he then went back into the bedroom, retrieved his gun, concealed it in his waistband, had plenty of time to be able to look at that gun and determine whether it was loaded or not. And based on all of that evidence, the reasonable inferences from that evidence, the jury was certainly free to find beyond a reasonable doubt that he intended to kill Diane Bailey when he put that loaded gun point blank at her head and pulled the trigger. And the jury was certainly free to to disbelieve his claim of self-defense, where by defendant's own admission, Jeff Hardy was unarmed, he was seated and starting to come out of his seat when defendant shot him the first time, and then the fact that defendant's own testimony was that first shot dropped Jeff to the ground, and then defendant shot him again. He claimed that it was because he felt like defendant was coming after him, but again, the jury was free to disbelieve that and see that that was more a shooting out of anger and not self-defense. Unless the court has any other questions about the sufficiency of the evidence, I'd like to move on to the jury issue and whether this was a capital case. Before 2007, all aggravated murders in Utah were capital cases. The legislature changed that in 2007 when it created a new classification of aggravated murder. Like I said, before 2007, all aggravated murders, or even, I can't remember when it changed, it used to just be first-degree murder. That was a capital offense. In 2007, the legislature said, we're going to create two different categories of aggravated murder. One will be a capital offense, one will be a non-capital first-degree felony. And the legislature explained that in order to determine which degree is at issue, it's incumbent on the prosecution to file a notice of intent to seek the death penalty. If the state charges aggravated murder and does not file that notice of intent, then the case is not a capital case. And that's exactly what happened in this case. In fact, the state under the statute, the state has 60 days from arraignment to file its notice. Here, the state made it clear right up front when it filed the amended information saying this is aggravated murder, a non-capital first-degree felony. Given that classification, there was no basis for the judge to impanel a 12-person jury. The Utah Constitution makes it clear that a 12-person jury only applies in a capital case, and the cases that defendant relies on, James and Roll versus Larson, those cases follow, as he puts it, the classification theory, but it's up to the legislature to determine what the classification is. When Roll and James were decided, every aggravated murder or first-degree felony murder was a capital case, and therefore, even if, because of the United States Supreme Court decision in Furman, even if the death penalty was no longer applicable or could no longer be applied in that case, the capital procedures that the Utah Constitution and statutes mandated applied. That was the holding in those cases. As Your Honors have noted, the statute has changed, and now it depends on whether the state charges aggravated murder as a capital offense by seeking the death penalty or as a non-capital offense.
So you think the term capital and death penalty are, at this point, absolutely coextensive. It's a if the prosecution is seeking the death penalty, it's a capital offense, and otherwise it is not.
Exactly. And because the legislature determines the classification of crimes. And here, the legislature made it clear that you can have an aggravated murder that has a penalty less than death, and that if that's the case, or if that's the charge that the state is pursuing, there are different procedures that apply. And
I'm sorry, did the James and Roll case, did the analysis in those cases depend on the classification of the crime or on the nature of the penalty? And what was the basis for the courts?
The court made it clear that it's the classification of the crime, because in James, I don't know exactly the timing, but Furman came down before James went to trial on his capital offense, his first-degree felony murder, and the state was seeking the death penalty, but of course the United States Supreme Court said that's unconstitutional as it's currently being applied. And so the court held a pretrial conference saying, I know that under Furman, the state can't seek the death penalty, and so therefore we will not be applying the capital procedures in this case. It went up on appeal, and the Utah Supreme Court reversed because it said, under the classification theory, if this crime, first-degree felony murder, is classified as a capital offense, which it was, then it doesn't matter that the death penalty couldn't actually be applied. The classification of the crime controls, and therefore all procedures that are necessary for that classification of cases had to have applied. And so James, in that case, got a new trial.
And is that why the legislature changed the law?
Well, it was a long time after James that they did. So I don't know that you can say that. It probably was in their mind when they were considering that. I think, I won't speculate exactly as to why the legislature changed it. But let me just add on this point as well that the fact that life without parole was a possible sentence does not turn this into a capital case. The Utah Supreme Court has repeatedly held in Met versus State, in State versus Reese, in State versus Perea, the court has repeatedly held that life without parole is qualitatively different than death, and that all of these procedures, a 12-person jury, the beyond a reasonable doubt standard, the extended jury voir dire that happens in capital cases, all of those things only apply when the death penalty is a potential punishment. Because it wasn't here, those procedures don't apply to a prison sentence.
What, if anything, Mr. Ballard, do you make of the several articles that are included in Mr. Morgan's brief, the thrust of which is scholarly opinion, anecdotal information from defendants that are in prison on a life without possibility of parole sentence, et cetera, all seem to suggest that life without parole is every bit as bad as the death penalty.
Well, I think they even suggest that it's worse in some, or can be perceived as more onerous than the death penalty. My response is that the Supreme Court has repeatedly considered that argument and repeatedly rejected it. I think it's a valid way to look at the consequences of the two penalties. I think the distinguishing difference is the fact that a life without parole sentence can always be revoked. A death sentence, once it's carried out, cannot be. And so given the finality of that punishment, it makes it unique among punishments, and that is why there are so many additional procedures, so much additional expense that goes into litigating those kinds of cases. I think that's probably one of the reasons that the legislature decided to reclassify aggravated murders. Life without parole can be revoked. If the legislature of this state for some reason decided that it was in fact too onerous of a punishment, if those scholarly articles and studies at some point become convincing enough, then the legislature can repeal that punishment, and those who are imprisoned under that punishment can then have an opportunity for parole and have their chance before the Board of Pardons. I think it's that key difference that distinguishes between those two penalties.
Well, and I suppose for the same policy reasons, the legislature could come in and decide that individuals who have the potential of life without the possibility of parole should get additional safeguards.
Exactly. The legislature could do that as well.
But it's up to them to classify the particular crime.
Right, to classify the crime and to classify the number of jurors that should be selected, as well as any other procedures. The legislature could say that you need specially qualified counsel even if it's just a life without parole sentence as opposed to a death sentence. All of those kinds of procedures. That's exactly right. In the final seconds here, let me just address defendant's waiver argument about his right to be present at Voir Dire. Defendant has not provided an adequate record for this court to be able to decide that that waiver was anything but voluntary. We have no idea what defendant and his counsel talked about, and it's clear that on the record that the defendant's response when the court reminded him, you do have a right to be here, are you sure that you don't want to be here? Defendant's response was, I've talked about this with my counsel and I trust his advice. And so given that the state of that record, this court can't hold anything other than that was a knowing and voluntary waiver.
I have a factual question about
Sure.
that. I couldn't tell from the briefing whether or not the defendant was present for some of the voir dire and then just not there when it went in camera, or if he wasn't present for any of it. Is that clear from the record? Do you know?
As best I can tell, all of the prospective jurors filled out questionnaires. And so defendant and his counsel had those to go over before they even got to court on the first day of jury selection. Then what the record shows is that on that first day of jury selection, they had split up the prospective jurors into 3 different groups. They brought the first group into court, and defendant was present in open court as the court began its initial voir dire process. Are all of you citizens of the state? Have any of you been convicted of crimes? Kind of the questions that apply to everyone generally. And then after engaging in those initial questioning with that first group, which defendant was present for, then the court said, I'm going to take jurors back individually and question them about more sensitive matters in my chambers. And it was at that point, as they were preparing to do that and recessing, that defense counsel said, my client has decided that he doesn't want to be here for that part. And then I'm assuming that and then at that point, defendant said, not only do I not want to go back into chambers, but I want to go back to the jail. I don't want to just sit in the courtroom through this whole proceeding. And so I'm assuming that he was not present for any of the other voir dire for the other 2 groups of jurors. But again, he had the jury questionnaires to go over with his counsel, and the record does make it clear that counsel said he wanted his client to come back before they started doing the peremptory challenges so that they could, I guess, discuss anything that came up in that individual voir dire.
Okay, thank you.
Thank you, Mr. Ballard.
Thank
Mr.
you, Your
Morgan,
Honor.
3.5 minutes.
I'll try and save the court a couple of seconds on this. First of all, Your Honor, I think I have to address the capital versus life without parole distinction. Your Honor, the court here is the Court of Appeals, and all of the appellate courts are here to ensure that defendants' rights are not impinged upon by legislative action or arbitrary action by the government. And this is precisely that case. In this matter, you have heard the argument that because the legislature decided that the prosecution 60 days before trial, 60 days after arraignment, can now take away all of the abilities of the defense to put together a thorough trial and come to just conclusions just because they think so and they want to call a capital case some sort of weird language that says life without parole is no longer capital because we said so. And as the Court of Appeals, I'm asking you to say you can't do that. That throughout...
Is it really weird language? It seems to me that the legislature was on the clear side of things when they redrafted this statute. they gave it a title called First-Degree Felony Aggravated Murder dash Non-Capital Felony. It seems where the James case is deferring to the classification made by the legislature, how could they have been more clear that they were distinguishing between capital and non-capital?
The person who wrote that statute is one of the brightest people I've ever met. He's a great lawyer and a great writer. The legislature is a wonderful group of people who are not people who are engaged in capital prosecutions or defenses. Your Honor, I don't think that language is clear. I think it's sarcastic. I think it's language that takes away people's rights. If you call it a capital case from the beginning and then only take it away when the prosecutor decides that, well, maybe I'm not going to get the death penalty after all, that did not make it less than a capital case. The penalty is horrendous of life without parole. That's horrible. Your Honor, a prosecutor has always had the opportunity to say, I'm going to amend the information and I'm going to make this a first-degree felony and not a capital case where someone can be put in prison forever without any possibility of parole. The legislature did not change that. They merely gave the prosecution an additional advantage. And when they did, which is fine, they should not have taken the constitutional rights away that are inherent in a penalty that is so severe as taking away somebody's freedom for their entire life. It takes 16 years after a death penalty case for somebody to actually be executed. Life in prison is much more than that. Your Honor, it is a horrible, terrible penalty, and I would ask you to look out for the rights of people who face that penalty.
I see your time's expiring, but I do have a question. On all of the other issues that you've raised, the Voir Dire sufficiency, you've claimed ineffective assistance of counsel, but on this one issue, the categorization of the charge and the 12-person jury, you have not claimed ineffective assistance. Is that right?
That's correct, Your Honor.
So
I
we're
think-
reviewing this solely, and it wasn't objected to below, so we're reviewing it solely under plain error.
Yes, Your Honor. I think it is plain error.
Thank you, Mr. Morgan. Mr. Ballard, we appreciate the arguments from both sides. They definitely will assist in our consideration of the case, and as is our practice, we will take the matter under advisement and issue a written opinion resolving the appeal as soon as we're able to. With that, court will be in recess.